Finally, we are live. Season 1, Episode 1. I am Dave, 10-year intellectual property attorney, dealing with everything as you see the shirt, patents, copyrights, trademarks, as well as trade secrets. And man, I must admit to you guys, this almost didn't go. This happened today. I was very excited. I prepared really hard between yesterday and today to kind of gather the show and having some technical difficulties over the last 20 minutes, but we finally figured it out. Had to reboot the computer, start over the camera a few times. We finally got things to link up and connect, and voila, here I am. So hopefully you guys enjoy these more so show formats. I have a lot to cover today, as you saw the title. Beyonce wins her legal battle. We'll be talking about Will Walmart selling out the Wirkin bag, Planned Parenthood on fetuses IP, which I'm surprised that more people are not in an uproar about that. So I'm gonna give you my thoughts on that. Buc-ee's, hey, about a month or so, I did a video on Buc-ee suing Duckies. It seems like they're at it again, this time with a Texas gas station. So we have a lot to get off into today. A little bit of housekeeping. Please hit the like button for the algorithm, as well as hit the subscribe button. Love to have you guys a part of the IP community, where, again, as of today, we're doing a show kind of hitting on a lot of different topics in IP that happened over the past few weeks. But we do these interviews. We kind of break down current events, Shark Tank pitches. No, Shark Tank hasn't been around for the past few weeks, so we don't have a Shark Tank pitch from this past week to kind of break down and talk about it a little bit. But typically, when those Shark Tank episodes come out, we will spend 5 minutes or so kind of talking about that. And the way I'm going to format these shows is I'm going to talk, just think of it as like a weekly recap where I have longer form videos, 10, 15-minute videos that's talking about the Beyonce lawsuit and the Planned Parenthood and so forth and so on. But I'm going to do more of a weekly recap where I'm going to kind of hit these things really quickly, 3 to 5 minutes. I'm going to try to spend on these individual topics. And then, again, feel free to watch the longer form content if you want more information on it or more of a detailed breakdown or analysis by myself. But then we're going to spend about 15, 20 minutes or so at the end on the IP lawsuit. This time around, we have Buc-ee's suing a Texas gas station. Let's see what the Texas gas station is, just so you guys kind of give an idea of what's going on. Super Fuels. So this Texas gas station, Super Fuels, like I said, Buc-ee's is at it again. For those of you who don't know Buc-ee, I have some video content to show you guys my recent visit to Buc-ee's a few months ago. But again, as we get off into it here, I am going to pull up. We're going to listen to a breakdown of this interview from Shark Tank Bucket Golf. Now, for those of you who are not familiar with Bucket Golf was actually on a Shark Tank probably a few weeks ago, about a month or so ago, and I actually had an opportunity, thankfully, to interview Tyler from Bucket Golf. Man, you're talking about, look, the whole point of this show or this channel is for you guys to hopefully be able to create some IP and monetize off your IP. And Tyler from Bucket Golf, he has an amazing story. We're just going to show a clip. As you can see, it's a 46-minute interview, but we're just going to play a 2 or 3 minute clip just to kind of give you guys what the interview is talking about. I think this clip is talking about his Shark Tank experience, but you guys have to create IP. This guy, Tyler, just kind of give you a little bit of his story. He was a lacrosse player at the University of Denver. What else did he? He was a lacrosse coach at the University of Stanford out west. And then next thing you know, he kind of creates this game, Bucket Golf, that goes on to sell $12 million, I think, last year. So you're talking about this guy who was not heavy into sports, heavy into lacrosse, and next thing you know, this guy is a millionaire. Again, $12 million. I think he's making anywhere from $1 to $2 million pocketing in profits a year from Bucket Golf. And again, we're going to play a little bit of this the interview. And again, please feel free to go check out more of the full-length interview on Everything Intellectual Property YouTube channel. But let's go with this clip here, and then I'm gonna come back and we'll move on to the next topic. For sure. No, so then kind of moving on with like the Shark Tank experience. So what was that kind of mindset to say, okay, we need to go on Shark Tank? Because again, I was really impressed. A lot of times you get these Shark Tank pitches and I do these Shark Tank kind of breakdowns where I go through each. You had a pretty cool game, but then this game sudden I'm literally making millions of dollars. There we go. So I guess kind of what was that experience like? Because again, we know we only see 10 minutes, but I think you guys are in a tank for about an hour, just kind of going through that experience, being someone who have gone through it. What was that experience like, if you kind of still recall?
Oh yeah, it is kind of, you kind of black out a little bit, honestly. But the lead up process is like there's like a million like tryouts and all this stuff, video stuff you have to do. But then once you actually get the green light and you go there, it is super nerve wracking. I didn't think I was gonna be nervous really, just because it's like this is what I spend all day long doing. Like I know every single thing about the business. I know all to share it. But then once you actually get out there knowing that everything you say and do, and the worse it is gonna be put on the show potentially if you get aired, it's like it just makes you nervous and kind of like, oh man, this is actually very nerve wracking. Was kind of like the biggest thing I felt is just like it's nerve wracking, but it's also one of the most fun things ever when you literally like the doors are shut and then they open them and you walk out just like it is on the show, and you just see them there for the first time like in person, something you've watched so many times, and just getting to actually be out there and talk to them in person. It was just it was like a
A real moment, I would imagine.
yeah, it's surreal. Doesn't feel real when you're out there. Wish I could relive the experience again, because like stuff ended up going our way when we were out there, kind of. So,
And again, that's all I wanted to complain of that. Man, thankfully, these guys actually end up getting a deal with one of the Sharks. Like I said, he's doing $12 million a year, which, again, in my opinion, is crazy to think. But again, good stuff on his end for him to be able to get a deal on Shark Tank. Please feel free to go, take a little bit more of a deeper dive of that interview on Everything Intellectual Property YouTube channel. So definitely kind of moving on there. So that's kind of that segment. So we'll move on to the Beyonce situation, where again, Beyonce, she again, the title was a little bit misleading from the Daily Mail, where they're talking about she was able to win her 12-year legal battle for trademarking her daughter's Blue Ivy name. And it's a little bit misleading because she actually had the opportunity, I think, when she originally filed for trademark protection in 2011, around that time frame, that USPTO actually granted her, they allowed her trademark. But again, when you file for trademark protection and the USPTO, you file a trademark application, they pick it up, they examine it, they're saying, okay, your trademark is allowed to be registered. We didn't find anything out there that was similar to your guys' trademark. You still have to complete the process. And what does that mean, Dave? That means you have to submit a specimen to the United States Patent and Trademark Office to kind of finalize things, to let them know that you're using a trademark, and then your trademark will issue into an actually registered trademark. And what Beyonce did, and I'm not going to read the article again, please feel free to go check out that kind of, I think the video ended up being 12 minutes on the channel, where I'm kind of breaking in a deep dive, but this is more of a weekly recap, where Beyonce never submitted that specimen, and as a result of that, her original trademark application was abandoned. So she actually was able to get trademark protection on the name Blue Ivy originally, and she didn't complete the process, so the application was abandoned. And that kind of goes maybe to a bigger point, where I think she was saying, talking about, her and Jay-Z was talking a long time about, hey, they just want to trademark the name Blue Ivy to keep others from being able to monetize off of it. And unfortunately, trademark law does not work like that. With a patent, you can get a patent and sit on it. With a copyright, you can get the copyright and sit on it. But with a trademark, you got to think these things last forever. So as a result of these things lasting forever, you have to actually be using them. They last forever, I should say, only to the extent that you're using a trademark. So I'm not sure if Beyonce and Jay-Z's trademark attorney didn't consult them or kind of let them know what the real is, but you can't get a trademark and just sit on it. It seems like that's what they're trying to do. So when they initially got the mark allowed to complete the process for it to register into a trademark, they never did that. So the application went abandoned. Then what I think a couple years ago, 2023, around that time frame, they tried to resubmit a trademark application, which is totally fine, for the term Blue Ivy to trademark it. And what the USPTO, the examiner at the USPTO did this time is they cited, I should have had it's a clothing boutique out in Wisconsin, a lady who was running a clothing boutique called Blue Ivy, and she actually got that term registered with the trademark office. And now this time around, when Beyonce and Jay-Z is trying to file for trademark protection for the term Blue Ivy, the examiner at the USPTO cites that Wisconsin clothing boutique against Jay-Z's and Beyonce's trademark application, and a little bit of back and forth kind of pursued. And it seems like Beyonce and the team put forth arguments. Unfortunately, it seems like the Blue Ivy, the clothing boutique in Wisconsin that's named Blue Ivy, didn't kind of respond to Jay-Z and Beyonce's arguments. And ultimately, this time around, the Carters was awarded, or again, the trademark application was allowed again out. She still has to complete the process. They still have to submit the specimen to complete the process and have the trademark application actually register into a trademark. So we'll see if they actually do that. But it seems like up until this point in time, their arguments that they put forth, they worked, and as a result of it, the application was allowed. Now, like I said, they still have to complete the process, and this brings up another good point. When you're filing for trademark protection, you actually are playing with fire when you file for trademark application, file for trademark protection, and then let the application go abandoned and then try to do it later on again. Now, in this case, it actually worked out for Beyonce and Jay-Z because, the arguments kind of put forth, it seemed like worked. But, sometimes you're not lucky, and you may have somebody else that once the application goes abandoned, somebody else is free to file for trademark protection for that term or that logo. And it may not work out for you the way it did for, again, Jay-Z and Beyonce, as far as kind of the arguments persuading the examiner at the USPTO and the actual mark being awarded. So kind of definitely be conscious of that because, again, to the extent that the mark, the logo, the word, whatever it is that you're trying to get trademark is available, anybody can get trademark protection on it. And like I said, in Beyonce and Jay-Z's case, they were allowed to register the mark. They didn't complete the process, 10, 12 years ago. And for whatever reason, a long gap was in a process. And then they recently refiled in 2023, where that clothing boutique in Wisconsin popped up, and they were able to get over that hump or get over it. And I actually got a good comment under the video that I did for that one. Please go check it out, where someone was saying, hey, so what happens to the clothing boutique in Wisconsin? Can she use the mark now? And the answer is simply yes. What the USPTO simply found was, hey, it's not a likelihood of confusion. That's the whole standard of trademark law. Is your mark, is somebody else's mark trying to register it in the future? Would it be a likelihood of confusion with your mark, your previously registered mark? And the examiner at the USPTO simply ruled is, hey, the mark Blue Ivy from Jay-Z and Beyonce's application is not a likelihood of confusion with the Blue Ivy clothing boutique in Wisconsin. So both of them are allowed to use the mark for their respective purposes and kind of go from there. So that's it. Kind of moving on here. I do want to do some housekeeping here. So Chalkless, hey, you guys have to kind of give this product a try. I actually interviewed them, Chalkless, and they were another Shark Tank guest that were on Shark Tank, was able to get a deal in. Again, fortunately enough, was able to interview these people. I mean, again, that team is rock solid, so definitely go check out the interview. But the actual product is phenomenal. And to the extent that you want to use Chalkless or buy Chalkless, whether you are playing sports, football, basketball, whatever the case may be, whether you are military personnel, trying to kind of grip objects, things like that, whether you're a weekend warrior or otherwise, Chalkless is something that you can use. And as a name states, it is not chalk. This is not chalk. This is a lot cleaner than chalk. And the grip is a lot stronger than something that you would get with the white chalk that you typically use in whether you're weightlifting and things like that. So definitely go try out the product Chalkless. It's a discount code in the description section. I wish I could pin it to the top. I have to figure out how to pin it to the top of the chat. But if you use the discount code David Spears, you get a 10% discount on on whatever your order is. So definitely go check out Chalkless and kind of go from there. We're going to move on here too. Let me kind of pull this up here, man. This is pretty cool. Just the Birkin bag. Walmart has its working bag, I should say. That is, I'm going to play this video here. Seems like we have to disable an ad blocker. But Walmart came out with its own Birkin bag that's being deemed the working bag. So we're going to play this video and kind of see what they're talking about. And again, I'm going to give you guys my thoughts on this one. Now, for those of you, you're like, hey, man, what is Birkin, a bag? Is that kind of copyright? Is that kind of trademarks? Is that patents. What is that, Dave? Now, a bag, at least in Hermes' case, that their Birkin bag is protected by trade dress, which is a subset of trademark law. And as I said before, trademark law lasts forever, and trade dress law lasts forever to the extent that you're using a bag. And we all know Hermes bag is an extremely popular bag that they make a ton of money on. So I would imagine that they'll continue to look to protect their bag. So let's kind of take a look at the news and see what they say, and I'll give you some of my thoughts.
Getting behind the wheel of a new Buick has never been easier. Shop online and purchase or
In Consumer 10 tonight, is it real or is it fake? Well, when it comes to fashion finds, does it even matter?
For those looking for a deal, one posted to Walmart might have been the deal of the century, but it's already come and gone. But legal trouble may follow it. Walmart had said these purses were available for $100. Now people online are calling these bags Wirkins because it has a striking resemblance of the Birkin bag made by luxury designer Hermes. Walmart apparently took down the bags after it sold out, but the dupe products might be in a gray area of the law. Consumer 10 talked to a consumer class action lawyer to explain why.
So that's all I'll kind of play of that. But as I kind of bring it back on myself with this one, now Hermes has not formally sued Walmart. There's no lawsuit out there. I would imagine that behind the scenes, both of their legal counsel are talking. As the gentleman announced, Walmart has sold out the bag. You're talking about a bag that's selling for $78 at Walmart. That's similar to the $15,000 plus bag that Hermes sells. And I'm always, you guys have to let me know in the chat. Let me know in the comment section. Is it that important to look like you have the real bag? I know a lot of times you see this stuff with Louis Vuitton where you'll see knockoffs on the corner, people selling Louis Vuitton bags for $300, $500, where we know Louis Vuitton bags a lot of times go for thousands of dollars. And this is a similar case. Now, in this case, Walmart is doing it, and I would imagine that Walmart kind of did his homework. And I think they will be good because of the level of customer care that a consumer will take in buying a Birkin bag. Now, if this Birkin bag costs $500 or something like that, $300, and Walmart was selling this lookalike for $100, Walmart may be in trouble. But you better believe in this case, if somebody's paying a $15,000 price tag for a Birkin bag, they probably know that, hey, this bag is not going to be sold in Walmart. And if I get a $100 lookalike bag, it's probably not the real thing. So that's one of the defenses to trademark infringement is the level of care taken by the customer. And again, go please for further detailed analysis of that. Please go check out the longer video where I'm kind of breaking down the Walmart Wirkin bag against Hermes Birkin bag. But again, is it that important for you to look like you have the real thing that much to the point where you're like, hey, I'm gonna go pay $100 for a lookalike bag and kind of go out into the world and look like a 1%er at that point? I'm not sure, man. I think no, but I guess other people may feel differently about it. I'm always amazed at that. Just kind of work hard and try to get the real thing. But I guess some people want to just look like the real thing for a day or so. Let's kind of move on here to Ford. Now, again, I kind of broke this down as well. Ford has just filed for patent protection on the pivotable carrier assembly, or essentially a spare tire carrier for its Ford Bronco. And again, we'll see whether or not it gets patent protection on it, but this is essentially it. Like I said, I did do a more of an in-depth breakdown on this. So go check out that video on the channel for a more in-depth breakdown. This is, you see here, figure 1. And actually in the video, again, I really want to teach you guys IP, particularly patents and whatnot, so that you guys can create and protect your IP and monetize off your IP. And part of the long form video, I'm teaching you how to read a patent claim so you kind of understand the lingo of it, which is going to help you when you're talking to an attorney. But this is, again, in figure 1 that you see here. You see the carrier assembly, which is 22. It has the tire in a closed position. The carrier is in a closed position, and you see the spare tire 26 there. Then if you go down to figure 2, you see the carrier assembly that's denoted as 22. It's in an open position, which you see the open position. That spare tire is separate from what that rear door or tailgate assembly, whatever you want to call it. So again, that's kind of, I don't know. I think it's interesting. In the Ford Bronco, I have a buddy who has a Ford Bronco, and it's a pretty sweet car. Now, it's not the OJ Ford Bronco, but nonetheless, it is a pretty cool car. So these are some more drawings of the patent that was filed by the patent application that was filed by Ford. And yeah, definitely go check out that full-length video to get a lot more details. But again, there you go, Ford files for patent protection on a carrier assembly. Now, they're not filing for patent protection on a door. They're not filing for patent protection on a spare tire, but it's the carrier assembly, again, 22, that's connected to the door and supporting the spare tire. And it's kind of moving that spare tire between the stowed position, which you see in figure 1, as well as the deployed position, which you see in figure 2. So again, go check out that video. Like I said, I thought it was a pretty interesting one that you guys would get something out of. But kind of moving on here, which I think this is a very interesting topic that not enough people are talking about. So Planned Parenthood, and I'm going to bring up the contract and we're going to kind of get off into it. But, and I'll say this before I get into it. I was probably one of the few people, and I'm not sure if I get in trouble for saying this or if the government is going to start looking at me a little bit more closely, but I'm probably one of the only few people who didn't take the shots for COVID. And it's just from, especially me being an African-American male, I just don't recall a time that the government tried to help out African-Americans, whether it's financially, whether it's on the healthcare side, whatever the case may be, businesses. It was never a time that the government went out his way so much. So when you're seeing the government kind of parade celebrities and families on these commercials and say, hey, go take the booster shot or take the COVID shot as well as the boosters, it was like, okay, just common sense is like, something is up about this. And as a result of that, no, I didn't take, and I was probably one of the only few people probably in the United States from an African-American standpoint that did not take the COVID shots, none of the COVID shots. So in this case, the reason I'm kind of equating that to Planned Parenthood, because Planned Parenthood has kind of went into, I guess, business, so to speak, with the University of California, San Diego, such that, hey, all the aborted fetuses that Planned Parenthood has, they're going to give them to the University of California, San Diego for research, and all the IP, the intellectual property, the patents, the things that they find that's, okay, maybe valuable, Planned Parenthood is keeping that. And the reason that's important is because we all know the overwhelmingly majority of I guess, the group that has the most abortions is the African-American community. So, and it was a case, and again, please go check out the longer form video that I think is like 15 minutes on the channel. It was a case actually back where I was in law school called the Henrietta Lex case, where she kind of had this bump or whatever the case may be, and she went to the doctor and it was like a tumor. They cut it. It was a black lady. She was in her probably 20s, and unfortunately she ended up dying maybe years later. But it was a tumor. They cut it out, sent it to the lab to do research. They kind of found out it was cancer, but in the process of kind of doing the research, it was something special about kind of her tissue that they were able to kind of put to good use, and it had a lot of economic value to it. And actually, based on that case, I was in Atlanta maybe like 3 or 4 weeks ago for the Celebration Bowl with Jackson State and I think South Carolina State, and Benjamin Crump was there. He was at the same hotel that I was staying at. You guys know Benjamin Crump, the civil rights attorney who's kind of everywhere. He was at the same hotel that I was staying at down there for the game, the Marriott Hotel. Shout out to Benjamin Crump. But he actually just recently, I think last year or maybe 2 years ago now in 2023, he helped out the Henrietta Lex family to get an award based on the injustice and the mistreatment, where kind of these research labs and hospitals were making a ton of money off her her valuable tissue that they kind of found. And they essentially sued, and Benjamin Crump was their attorney, and that just settled like a couple years ago, and he got them a ton of money. So the amount was undisclosed, but I would imagine that it was millions. So I'm kind of, again, saying all that to say that, going back to Planned Parenthood here, I'm going to pull up the actual, let's see here. Let me pull up the contract. But again, with Planned Parenthood, they're essentially in bed with the University of California, San Diego. And I'm still surprised that is not more of an uproar on this, where for all the aborted fetuses, they're given to the university so that they can do research to see if it's anything special about the fetus, the tissues and things like that. And to the extent that it is, and it's kind of economic value, Planned Parenthood is owning the IP. What does that mean? They're owning the patents. They're owning the trade secrets, things of that sort, which Man, it seems a little shady to me, especially since we all know that majority of these abortions are done from are based out of the African American community. Let me kind of point it out here. So you see here, I'll read this, and the contract made for valuable consideration grants University of California, San Diego access to fetal and placental tissue, which are proprietary materials of Planned Parenthood San Diego. So Planned Parenthood owns that material. The parties agreed that in granting access to the proprietary aborted fetal body parts, that's crazy. Planned Parenthood San Diego shall retain all right, title, and interest into the material, including but not limited to all right, title, and interest in patents and patent applications and other intellectual property rights relating to material. Man, that's crazy. And like I said, I don't think enough people are talking about this, but essentially, Planned Parenthood they're owning the patents to these aborted fetuses to the extent that they're found to be have valuable economic value. Even so much so, this is the messed up thing about this. At least they put in a contract for everyone else, like for example, the African Americans, that hey, these aborted fetuses may have economic value, and as a result of economic value, we own that. Or I've never had clearly I've never had an abortion as a male, but I would imagine that with Planned Parenthood, are they paying for it? Is it like free? Are they giving free abortions at that point? And as a result of it, they're retaining the rights to the IP. For those of you who maybe kind of know a little bit more about that, please leave it in the comment section. Is Planned Parenthood giving free abortions, or is it like a nominal cost for the abortion? I would imagine that they're giving you free abortions, and in turn for the free abortions, they are keeping the IP for all, the tissue, anything valuable that as a result of the abortions. But in the case of the Hispanics or the Latina community, they weren't even telling them that, hey, the aborted fetuses may have economic value. They were just saying, hey, we're going to retain all the IP rights to it. They're not even telling them that in the contract that these aborted fetuses may have economic value. So, I mean, again, like I said, I think this is not being talked about as much as it should be. Hopefully, kind of start this off, but I just think it's shady stuff for Planned Parenthood to be owning IP from aborted fetuses. So we're going to move on here to Buc-ee's. Now, for those of you who don't know Buc-ee's, I think my video of me being there a couple months ago will kind of give you a better idea of compared to me talking. Let's see if I can kind of play this video. This is not the right video. Let me see here. Look at, man, we in Buc-ee's. You see the Buc-ee's? Hey, we got Flip in the background. Look at this long gas station. What the fuck is this? Is this not the biggest gas station you've ever seen? I'm about to go in here and check it out. I'm gonna come back to y'all once I'm in this thing. So that was the outside of Buc-ee's. As you can see, it has a ton of pumps, gas pumps, I should say. Let me see if I can pull up the video here of me being inside Buc-ee's. Like I said, man, Buc-ee's, it was a crazy experience. We're not gonna talk about that sandwich I had with Buc-ee's that I end up coming up later, probably because kind of partying too much. But I'm not gonna hold Buc-ee's to that one. But here's me inside Buc-ee's. Look, I just ate, but this is like crazy in here. We in Buc-ee's. You want the sweets? We got the sweets. The hot sandwiches. Look at, you want the clothing? This whole section back here is just for clothing. They even got Christmas pajamas in this joint. It's like a big dumb gas station. Sam's Club restaurant. They got the ice cream right here. Look, they got chips. Yeah, this is crazy in here, man. Look, they got the Christmas tree, the Buc-ee's Christmas tree. And then you just got your regular gas station stuff back there, man. So I just had to tap in with y'all and let y'all know that we in Buc-ee's. I'm about to grab something. I'll holler. So that was my experience in Buc-ee's, and I think that Buc-ee's was the one in Tennessee. Obviously, you see the beaver. That's their sign. So they have a trademark not only on the logo, the beaver with the red cap. that's kind of smiling with the one tooth that's kind of encircled with the yellow background. They also have a trademark on the name Buc-ee's that you see here on the screen. And I did a video, like I said, probably like a month ago, where Buc-ee's sued Ducky's. I forget where Ducky's was out of, and obviously that name sounds a little bit more kind of similar to Buc-ee's. But this time around, let me kind of pull up the article here. We're going to go through this lawsuit. So this is a trademark lawsuit Buc-ee's recently filed against, pull it up here, against the Superfuels, which again is a Texas gas station. And we're going to go through it here really quickly. And I want you guys to let me know, do you think, based on the information, just kind of keep this in the back of your head, based on what we're going to read, do you think Buc-ee's, or essentially the Texas gas station Superfuels, is committing trademark infringement against Buc-ee's? Now, again, you see the Buc-ee's logo that I have up. We're going to read the lawsuit and kind of see what the Ducky's logo, I mean, not the Ducky's logo, but the Superfuels logo is. And I want you guys to be the judge of whether or not it's trademark infringement. So, again, this is in District Court, Northern District Court of Texas, the Dallas Division. All trademark or really IP cases are at the federal level, whether it's trademarks, copyrights, or patents. They're all at the federal level. Let me see if I can. Oh, shoot. I'm going to have to kind of take down the sign here so that you guys can see. Okay, here we go. Here we go. So plaintiff Buc-ee's, buying through his undersigned counsel, files this original complaint against defendants, Superfuel and other Superfuels. So let's go through it. Upon information and belief, defendant Superfuels is a Texas LLC with its principal place of business in Dallas, Texas. Okay, oh, that's good. That's good. Let's just kind of skip some of the stuff that's okay. Let's get to the factual allegations. What is Buc-ee's alleging? Buc-ee's owns and operates a nationally renowned chain of convenience stores and travel centers under the mark Buc-ee's. For more than 40 years, that's crazy, they've been around 40 years, plaintiff has proudly provided quality convenience store and gas station services under the Buc-ee's brand, which has been widely known throughout the U.S. in connection with Buc-ee's offerings. Buc-ee's was founded in 1982 by Art Beaver Applin III, who opened the first Buc-ee's convenience store in Lake Jackson, Texas, area with the goal of providing a clean and friendly environment for consumers. So Buc-ee's actually originated in the state of Texas. What began as a single convenience store has rapidly grown into a national phenomenon and has become a must-stop, one-stop shop for consumers across the country. I probably would agree with it. I was happy when I saw that Buc-ee's sign. I said, we got to stop. For many, Buc-ee's has become the rare brand like Apple and Costco that inspires loyalty that goes well beyond rational consumer calculations. That's funny. That's funny. The Buc-ee's brand has significantly expanded its geographical footprint for over the years. There are currently 51 Buc-ee's establishments spanning across 9 states, namely Missouri, Alabama, Florida, Georgia, South Carolina, Tennessee, Kentucky, Colorado, and of course Texas. See, I think I've been to the one in Tennessee. I think they had one somewhere in the Midwest. Maybe that was Tennessee. The one I saw on the highway. Plaintiff travel centers are famous for providing consumers with a unique roadside experience that features several widely acclaimed amenities, including plaintiff signature spacious restrooms. And the restrooms, they were similar to the gas station. These restrooms had like 50 stalls. It was the biggest restroom I ever seen, that's for sure, which are routinely ranked among American clean. It was pretty clean. I can attest to that. The bathroom was pretty clean. And its massive facilities and parking lots would generally span over 50,000 square feet and boast dozens of fueling positions. Plaintiff large-scale convenience stores are also offer a variety of flavorful Buc-ee's house brand food items and an array of Buc-ee's branded merchandise and souvenirs. I would probably agree with that. So again, these are obviously some of the stuff, the marks that I had just pulled up. These are Buc-ee's trademarks. So they have they have a few trademarks. They have just the black and white. Then they have the more colored trademark with the red cap and the yellow background. Plaintiff, the owner of common law trademark rights into the Buc-ee's Beaver logo in connection with this extensive array of goods and services, including the. So they're essentially saying, hey, we not only have a federal trademark protection with the USPTO, we also have common law rights. And this is the federal trademark registration numbers. And this is the chart. I like when they had the detailed chart right there. Pretty easy, straightforward to see. Let's kind of go back and see if we can. Those are the gas stations. You got the Buc-ee's sign out front. Beaver Nuggets. I didn't see the Beaver Nuggets. That's the Buc-ee's logo. You got the Buc-ee's signage inside of it, outside. Bringing back memories, man. So due in large part, let me see if I can, man, you have to do something about that sign. Nonetheless, due in large part to the substantial growth of successful Plaintiffs Traveler Centers and the brand, the Buc-ee's mark have become a cherished icon. I'm not sure if it's an icon, but it's definitely maybe a must-stop shop by legions of patrons across the nation. And indeed, as a segment that aired on CBS News' nationally syndicated Sunday morning program a couple years ago, perhaps not since Mickey Mouse as a cartoon rodent captured the hearts of so many. Would you call a beaver a rodent? I don't know. As a result of plaintiffs' prominent and extensive use and promotion of the Buc-ee's marks, the trade in purchasing, see here. What does Brandon says? The Buc-ee's was insane. Super dope, though. You have to let me know, what was your, what Buc-ee's did you go to? Was it the one in Colorado, Tennessee? And I guess what was the favorite memory of Buc-ee's? And I had a sandwich that it was good, but you know, it came up later on that night, but I probably overate and probably was indulging too much later on that night. So mixing things that shouldn't have been mixed. Let's continue on here. As a result of plaintiffs' prominent and extensive use and promotion of the Buc-ee's mark, the trade and purchasing public has come to know and recognize the Buc-ee's mark as a source identifier. I mean, I would imagine, I can agree with that. You see that beaver, you think Buc-ee's. You see the word Buc-ee's, you think a long gas station is or a massive gas station is upon us. So let's see what the defendant, let's see what Superfuels did. Defendants own and operate a chain of stores under the name Superfuels, which offer retail services featuring convenience store items and gasoline. Upon information to believe, defendants currently operate 3 Superfuel stations in Texas. Okay. Superfuels are using the below reference mark. Let's see what marks they're using. Clearly, it's not as massive as Buc-ee's, but you see here the it seems like a baby. I guess you can call that a beaver, maybe a red cape. Do you think that's similar to that? Do you think this beaver to the right that you see the register R, which means it's a registered trademark of Buc-ee's, do you think that's similar to the Superfuels beaver and the cape mark to the left? If so, if it's a likelihood of confusion, it's trademark infringement. If not, then it's all good. Let's continue reading here. Okay, there you go. That's probably a better view of it there. I mean, it is a decent sized gas station, though. Clearly, it's not as massive and has as many pumps as Buc-ee's, but I can see some resemblance there. You see, like I said, you see, I guess this is a beaver in a cape. Maybe it's something else, but it looks like a beaver in a cape. You see the circle there. It seems like it's blue in the circle as opposed to the yellow that Buc-ee's has. The Buc-ee's beaver is in. But I see some resemblances. I'm not sure if I'm convinced that it's a likelihood of confusion. There you go. There's another mark there or another picture of it. What do you guys think? Is this trademark infringement? Let me know in the comment section. If you was passing a sign that has this, I guess, beaver, some could say it's a dog with the red cape on, would you think that's Buc-ee? Would you think that this is the Buc-ee's here? And look, it seems like Buc-ee is stretching on this one if I had to guess. It looks like Brandon is agreeing with me. It looks like this is stretching, no confusion whatsoever. I tend to maybe agree with you. Do you think, for those of you who are just joining us, do you think that it's trademark infringement? What is trademark infringement? The standard is a likelihood of confusion. Are you and me, we're all kind of people that will be on a jury. This is the Buc-ee's mark on the right-hand side that's in yellow that has the beaver with the red cap on. Do you think that this, I'm not sure if it's a dog or if it's a beaver with the red cape on to the left. Do you think, would you be confused if you saw that sign and think that that's Buc-ee's? And I think they have a hard, I think Buc-ee's is I think they're pushing it with this one. But let's read on and see what more is Buc-ee's saying in the complaint. Defendants' use of the infringement mark is likely to cause consumer confusion in the relevant market as to the source of origin. Clearly, they're both gas stations, so that's something that I guess Buc-ee's has going for them. As illustrated above, defendants' infringement marks prominently feature an anthropomorphic and cartoon representation of a smiling animal that closely resembles a beaver, which is similar position in the right facing angle. Do you guys think, is this a beaver or is this like a dog? Maybe a fox? Clearly, just because you have trademark protection on a beaver with a red hat on in a yellow circle, that doesn't give you trademark protection in anybody trying to use a smiling animal. That's the same thing I think with duckies, that they sued duckies a month or so ago. It was a duck that was more or less smiling. We thought that was a stretch. Let's continue reading. It seems like Ducky Superfuels, they just recently opened in 2022. There's no evidence indicating that Superfuels using the infringement marks prior to the date on which plaintiff began. So essentially they're saying that, hey, it was 2022. So they used their mark after we used ours. So let's go to 39. The infringement marks mimic the salient portions of the plaintiff's famous Bucky marks, including with respect to at least the following elements: the inclusion of a smiling cartoon style animal that closely resembles a beaver. Is that a beaver? I'm not sure. It looks like maybe it can be a dog. It can be a beaver. I'm not sure. The position of the cartoon style animal against a circular background. I would agree with them with that. They definitely have the beaver. They definitely have the beaver in the circular background, similar to kind of Bucky's beaver in that circular background. So I would give them a B there. The orientation of the cartoon style animal, which is similar face towards the right, I'd probably give them that as well. The coloration of the cartoon style animal, which is similar depicted with a brown coat. Okay, yeah, so they're trying to break it down on an individual basis. The expression and facial features depicted on a cartoon style animal, including with respect to a smile, upward snout, oval-shaped eye. So they're getting granular. Let's finish off here. The use of the brown as a primary color. Clearly, both animals are brown. The use of the red as a secondary color that matches the red color using the Bucky's mark. I'll probably disagree with them. This Bucky's has a red hat, whereas as you can see here, they have a red cape. So I think that's a stretch by Bucky's on that. But those are pretty much the features that they're saying are infringing. Let's continue to read here. That's where we're almost finished. Further, the services offered under defendant's infringing marks are identical to those offered under plaintiff Bucky's. It's a gas station, so they have gas station food. Let's see if we can go here. The likelihood of confusion created by defendant's use of the frightening mark is further exacerbated by the circumstances in which the infringing marks are encountered by consumers. Yeah, man, it's a gas station. So let's see what the cause of action is. You have federal trademark infringement, so that's under the Lanham Act. So that's count one as we finish up here. You have federal trademark infringement and unfair competition, count two. Federal trademark dilution, count three. Common law, Texas common law trademark infringement, right? So what a lot of people don't know is you have federal trademark rights, but then each state law has common law rights. Typically, the federal one is kind of the more important. Then you have unjust enrichment and trademark dilution under Texas law. So it seems like some Texas claim. And then they're trying to get the mark canceled. And I think what we didn't see, and I kind of bring it back on myself here as we look to wrap up, what we didn't kind of go over in that lawsuit is Superfuels actually has a registered trademark on their beaver, their fox with the cape. They actually was able to get a registered trademark, which I think Bucky's was dropping a ball on. So once you file for trademark protection, once the mark is allowed, and I kind of pull it back up, once the mark is allowed, you have 30 days. They publish the mark so that people can oppose the mark. And it's in and people can have 30 days to oppose the mark. And it seemed like Bucky's didn't oppose the mark when it was allowed initially. The mark becomes registered. Now they're trying to file a lawsuit. So I think Bucky's definitely dropped the ball because they could have, again, you see one of the counts they were trying to petition to cancel the mark. They could have did that years ago. Like I said, Superfuels has a registered trademark on their mark that I'll pull up again here one more time. Superfuels has a trademark on their essentially fox or beaver with the red cape. They have a registered trademark on that. So that's another thing. Just because, here, let me pull it up here so you can see it. Superfuels has a registered trademark on their fox or their beaver in a red cape. And Bucky's has their trademark on their beaver with a red hat. So just because you're suing somebody, that doesn't mean that they don't have a trademark. As you can tell, both of these companies have a registered trademark with the USPTO on their marks. Seems like Bucky's dropped the ball earlier in terms of being able to kind of prevent Superfuels Mark from being issued or registered, and now they're trying to file a lawsuit. I would imagine that they sent some cease and desist letter, and Superfield said go screw off, and lawsuit commenced. So again, that is another thing to be on the lookout for. You should be kind of checking, okay, what marks are allowed and are going to be registered. And if it's something that's kind of similar to mine, I need to petition the USPTO at that point to look to get the mark canceled. Because to the extent that it doesn't, or I drop the ball and not to file a lawsuit, you're going to spend a lot more money filing a lawsuit for trademark infringement than sending a petition to cancel the mark at the USPTO because it's similar to yours. So I'm not sure if Bucky would have won that if they would have petitioned to cancel the mark with the USPTO. I still don't think they would have won. I think they're stretching with the likelihood of confusion, but kind of here we are. So let me know in the comment section. Let me know in the chat. Do you guys think this is trademark infringement? As your boy Brandon said, no confusion whatsoever. Me being a 10-year intellectual property attorney, I would tend to agree with Brandon on this one. Hey, shout out to Buc-ee's though. I still think you guys have definitely something good going on with your establishment. Super clean, super dope, definitely massive, and kind of keep doing business. Like I said, I think you guys are going to have a hard time with the lawsuit with Superfuels on this one, but that's it. That's all I have for you guys kind of before we go here. Definitely please hit the like button for the YouTube algorithm. Please hit the subscribe button to be a part of the IP community where we talk about a lot. As I said, hey, in the description section, to the extent that you want Unreal Grip, whether you're playing sports, I know we have some basketball players, we have some football players. It's weightlifting time. I know that off season with football, weightlifting competitions, and I know the weightlifting competition using that white chalk. Hey, definitely try chalkless. Hey, the grip is definitely like no other, and it's not all messy. To the extent that you're in the military, go check it out. Weekend warrior or just an everyday person. We all need grip for different reasons at different points, and this is something that everybody can get down with. 10% off by using the discount code in the actual description. David Spears is the discount code, so definitely go check it out. Hopefully you guys enjoyed this one. I know we were a little late, and I didn't know we were going to even get up into the air, but we were able to kind of get started and kind of fly the plane and get it landed. So I'm excited about this season 1, episode 1 of just a little bit of everything. The Beyonce case. We talked about Planned Parenthood, Walmart. I have to kind of really be on the lookout to see if Hermes sues Walmart at some point. At this point, they haven't sued them, but we'll see if Hermes sues Walmart. Beyonce, we have to kind of see if she kind of goes all the way this time to complete the process to register the name Blue Ivy and see what she starts selling with that. Please go check out Bucket Golf again. They did $12 million last year. They got a deal with one of the sharks on Shark Tank, so they're killing it. Hey man, just be aware of the Planned Parenthood stuff, because that's big. Like I said, I think that's sketchy what they're doing, but that's kind of my take on it. And that's pretty much all I have for you guys. So I will be on time next week. I promise you guys that. Until next time, you guys take care.